Welcome back to Supreme Court Oral Arguments and Opinions, where we break down the court's most significant actions with analysis you won't find in headlines. In today's episode, I'll walk you through last week's Supreme Court developments across three areas: the 6 newly decided cases, 2 significant emergency docket actions, and 3 major cases the court has just agreed to hear. If you find this analysis helpful, please take a moment to subscribe, rate, and share. All right, let's talk about last Thursday's decisions. What jumped out immediately was the remarkable consensus. 5 cases were decided unanimously, while the 6th was an 8-1 dismissal. This overwhelming agreement on outcome tells us something strategic. With at least 30 contentious cases still pending and the term's end approaching, the court appears to be deliberately clearing its docket of straightforward cases before tackling the term's most divisive issues. And to be sure, unanimity in outcome did not mean unanimity in analysis. Quite the contrary, several justices used their concurring opinions to stake out less agreeable positions. Another observation. Each majority opinion came from a different justice: Thomas, Alito, Sotomayor, Kagan, and Jackson, showing a balanced distribution of opinion writing assignments. Justice Thomas emerged as particularly prolific, authoring either a majority or concurring opinion in 5 of the 6 cases. The only exception was the LabCorp dismissal. His concurrences weren't mere agreements, but intellectual roadmaps challenging judge-made doctrines that lack textual foundations. In Ames, for example, he explicitly called for reconsidering the McDonnell-Douglas framework, laying groundwork for future doctrinal shifts. Thomas is playing the long game, using these concurrences to build momentum for his textualist approach. I also noticed the court's heavy focus on procedural rules. 3 decisions, LabCorp, Blom, and CC Divas, directly addressed procedural questions, while others dealt with pleading standards and jurisdictional issues. This reflects a broader trend where seemingly technical procedural questions serve as proxies for deeper policy debates. Through these cases, the court reinforced fundamental principles about finality, jurisdiction, and court access without wading into politically charged waters. These June 5th decisions demonstrate a court operating with careful institutional strategy, building consensus through technical precision while positioning for future doctrinal developments. But the court's work extends far beyond its merits docket. Turning from these carefully crafted unanimous opinions to the court's emergency docket reveals a different dynamic entirely, where urgent requests for relief often expose deeper ideological divisions and force the justices to make consequential decisions with limited briefing and deliberation. The first development occurred on June 6th in US DOGE Service versus Crew, a case I previously analyzed in my May 27th episode called Cert Denial: Where Do Student Speech Rights End? The two genders t-shirt controversy, though as I'll discuss, this emergency docket filing represents a significant development from the court's earlier cert denial. At issue was a district court order that required DOGE officials to sit for depositions and to produce internal recommendations to federal agencies to determine whether DOGE must comply with FOIA in the first place. As you may recall, on May 23rd, Chief Justice Roberts granted a stay in a Freedom of Information Act lawsuit involving the U.S. DOGE Service. The Chief Justice also paused the litigation until further order of the Chief Justice or of the court. After a 2-week pause, on June 6th, the Supreme Court followed up. The Supreme Court granted the government's application for a stay and took the additional step of simultaneously granting certiorari. The court then vacated the D.C. Circuit Court of Appeals order that denied a writ of mandamus and sent the case back to the D.C. Circuit, not the D.C. District Court, for further consideration in light of this June 6th order. The June 6th order went on to address the district court's April 15th discovery order, ruling that portions were not appropriately tailored, including the portion requiring the government to disclose the content of intra-executive branch USDS recommendations and whether those recommendations were followed. In explaining its reasoning, the court stated that any inquiry into whether an entity is an agency for the purposes of the Freedom of Information Act cannot turn on the entity's ability to persuade. The court emphasized that separation of powers concerns counsel judicial deference and restraint in the context of discovery regarding internal executive branch communications. The court cited its previous decision in Cheney v. United States District Court, noting that special considerations control when the executive branch's interests in maintaining the autonomy of its office and safeguarding the confidentiality of its communications are implicated. As a result, the court directed the Court of Appeals to take appropriate action to narrow the April 15th discovery order consistent with this order. Both the April 15th and May 20th orders from the District Court are stayed pending the Court of Appeals reconsideration. Justice Sotomayor, Justice Kagan, and Justice Jackson would deny the application, meaning they disagreed with the majority's decision to intervene and would have allowed the discovery process to continue as the District Court had ordered. Though we don't have a written dissent from Justice Jackson or the other dissenting justices, their position is clear. They would have permitted the broader discovery that the majority has now halted. Two key points stand out in this order. First, the court directed the D.C. Circuit to narrow discovery rather than bar it completely. This suggests the court believes some limited discovery may be appropriate in determining DOGE's FOIA status, just not the intra-executive branch USDS recommendations and whether those recommendations were followed. Second, the court based its decision on separation of powers principles rather than procedural arguments. By focusing on judicial deference and restraint regarding internal executive communications, rather than prohibiting all discovery, the court implicitly rejected the government's position that no discovery is appropriate to determine agency status under FOIA. This represents a nuanced outcome where the government protected sensitive communications while Crew preserved the possibility of some discovery as the case proceeds. There's still a ways to go. Whatever the D.C. Circuit decides will likely end up back at the Supreme Court for final resolution. Let's dive into another DOGE-based case called Social Security Administration versus American Federation of State, County, and Municipal Employees, with a case number of 24A1063. On June 6th, the Supreme Court granted a stay of a lower court's preliminary injunction. This means the Social Security Administration can now give members of DOGE access to sensitive agency records while litigation continues. The majority didn't issue a detailed opinion, but Justice Kagan noted her dissent, and Justice Jackson wrote a full dissenting opinion, joined by Justice Sotomayor. The case stems from an executive order signed on January 20th, 2025, establishing DOGE to modernize federal technology and maximize governmental efficiency. When DOGE demanded access to SSA records containing personal data of millions of Americans, labor unions and an advocacy group sued, claiming violations of the Privacy Act and Administrative Procedure Act. Initially, a district court had placed temporary limits on DOGE's access to this data, and the Fourth Circuit Court of Appeals declined to stay that order. But the Supreme Court has now overruled those lower courts, allowing the SSA to give DOGE full access to the records. Let's briefly walk through Justice Jackson's dissent. She opens by framing the issue in stark terms. The court is allowing the SSA to hand over highly sensitive, non-anonymized personal data of millions of Americans before the courts have even determined whether such access is lawful. While Jackson focuses primarily on the procedural concerns with granting the stay, she does touch on the merits of the underlying case. She explains that the Privacy Act of 1974 was specifically enacted to protect the privacy of individuals identified in information systems maintained by federal agencies. She notes that Congress recognized the harm to individual privacy that can occur from government mishandling of sensitive information. Jackson points out that the Privacy Act prohibits agencies from disclosing covered data except in narrow circumstances, such as where agency employees have a need for the record in the performance of their duties. This legal framework forms the basis for the respondent's claims that DOGE's unfettered access violates federal law. Her dissent has a distinctly urgent tone. She criticizes the government for failing to demonstrate any irreparable harm would result from waiting for the normal litigation process. As she puts it, the government's urgency is simply that it cannot be bothered to wait for the litigation process to play out before proceeding as it wishes. Justice Jackson's dissent takes on a distinctly urgent tone. She criticizes the government for failing to demonstrate any irreparable harm would result from waiting for the normal litigation process. As she puts it, the government's urgency is simply that it cannot be bothered to wait for the litigation process to play out before proceeding as it wishes. Justice Jackson makes a colorful analogy, saying the court dons its emergency responder gear, rushes to the scene, and uses its equitable power to fan the flames rather than extinguish them. She notes this follows a pattern of the court granting emergency relief to the government without requiring it to meet the same standards other litigants must satisfy. What really stands out in Justice Jackson's dissent is her concern for the sensitive data at stake. She vividly describes the information in SSA's possession: social security numbers, birth dates, addresses, bank account numbers, and detailed medical records, including prescriptions, mental health treatments, and even HIV testing results. She also emphasizes that the lower courts crafted a reasonable compromise, allowing DOGE access to anonymized data and to specific non-anonymized records when necessary. But the government refused this middle ground, insisting on unfettered access despite never clearly justifying their need. Jackson concludes with a powerful critique of what she sees as preferential treatment for the government, warning that the court is creating grave privacy risks for millions of Americans in the process. That wraps up today's analysis of the court's June 5th decisions and recent emergency docket developments. The contrast between the institutional consensus we saw in those 6 unanimous cases and the more fractured dynamics of emergency relief requests illustrates the complex forces shaping the Roberts Court's evolving jurisprudence. While emergency actions give us insight into the court's current thinking, certiorari grants offer a window into the court's future agenda. On June 6th, the justices agreed to hear 3 significant cases that will shape next term's docket. Each raises distinct questions about fundamental legal principles that could have far-reaching implications beyond the immediate parties involved. The first case is called Coney Island Auto Parts Unlimited Incorn Petitioner versus Jean Ann Burton, Chapter 7, Trustee for VistaPro Automotive, LLC, case number 24-808. This case asks a seemingly simple question. If a court enters a judgment against you without having proper jurisdiction, how long do you have to challenge that judgment? Let me set the scene. Back in 2015, a company called VistaPro Automotive was in bankruptcy proceedings in Tennessee. As part of that bankruptcy, VistaPro sued Coney Island Auto Parts, a New York company, for about $50,000 in unpaid invoices. Here's where things get interesting. VistaPro mailed the lawsuit paperwork to Coney Island's address, but Coney Island never responded. The bankruptcy court entered a default judgment against them. Fast forward to 2021, 6 years later. when Vista Pro's bankruptcy trustee finally tried to collect by freezing Coney Island's bank account. Only then did Coney Island spring into action, claiming they were never properly served with the lawsuit in the first place. They argued that under bankruptcy rules, service to a corporation must be addressed to the attention of an officer or agent, not just the company name. Without proper service, they say, the court never had jurisdiction over them, making the judgment void. The courts in Tennessee, however, said too late, ruling that even motions to vacate void judgments must be filed within a reasonable time. And 6 years wasn't reasonable. Coney Island, the petitioner, makes a straightforward argument. A void judgment is a legal nullity from the start. If a court never had jurisdiction over you, its judgment can't suddenly become valid just because time has passed. They point out that 11 federal circuits agree with this position, making the Sixth Circuit the lone outlier. As they see it, the federal rules of civil procedure shouldn't be interpreted to breathe life into judgments that were dead on arrival due to a lack of jurisdiction. They argue this case has significant real-world implications. If the Sixth Circuit's rule stands, businesses and individuals might be bound by judgments from courts that never had authority over them in the first place, simply because they didn't discover the judgment soon enough. The bankruptcy trustee, on the other hand, argues there's not really a clean circuit split as Coney Island claims. They point out that many circuits recognize that motions to vacate void judgments can be untimely in appropriate cases. The respondent emphasizes the plain language of Rule 60C1, which says that a motion under Rule 60B must be made within a reasonable time, with no exceptions for void judgments. They argue the Sixth Circuit simply followed this clear text. Furthermore, they argue that accepting Coney Island's position would encourage parties to intentionally ignore court proceedings, wait years until memories fade and evidence disappears, and then challenge judgments as void. This would undermine the crucial principle of finality in our legal system. They also make a practical point. This case is a poor vehicle to decide the issue because Vista Pro's service was actually proper under New York law, so the judgment wasn't void in the first place. This case highlights the tension between two fundamental legal principles: the idea that courts should only exercise power when they have proper jurisdiction, and the need for finality in legal proceedings. The Supreme Court's decision could have far-reaching effects on how lower courts handle challenges to potentially void judgments across the country. The court will likely hear arguments this fall, with a decision expected by next summer. Stay tuned. We'll be following this case closely as it develops. The second case is Rutherford v. United States, case number 24-820. This case was consolidated with Carter v. United States, case number 24-860. This case could impact hundreds of federal prisoners serving extremely long sentences under a law that Congress has since changed. Let's break down what happened here. Johnny Carter was convicted of multiple bank robberies back in 2007. He received an extraordinarily long sentence, 70 years in prison, largely because of what's called stacking under Section 924C, which deals with using firearms during crimes. Under the law at that time, if you were convicted of multiple gun charges in the same case, each additional conviction triggered a mandatory 25-year sentence that had to be served consecutively. So Carter got 7 years for his first gun charge, then 25 years for the second, and another 25 years for the third, all stacked one after another. In 2018, Congress recognized these sentences were excessive and passed the First Step Act, which changed the law. Now, the 25-year enhancement only applies if you commit a second gun offense after being convicted of a previous one. But critically, Congress didn't make this change retroactive for people already sentenced. After the law changed, Carter sought compassionate release under Section 3582, which allows sentence reductions for extraordinary and compelling reasons. His argument got a boost in 2023 when the U.S. Sentencing Commission issued new guidelines saying that non-retroactive changes in law could be considered as extraordinary and compelling reasons if they create a gross disparity between the original sentence and what would be imposed today. However, the district court denied Carter's motion, and the Third Circuit affirmed that denial, holding that the Sentencing Commission had exceeded its authority by allowing courts to consider legal changes that Congress deliberately chose not to make retroactive. Carter's petition makes a straightforward argument. Congress explicitly gave the Sentencing Commission the authority to define what constitutes extraordinary and compelling reasons for a sentence reduction. The only limitation Congress imposed was that rehabilitation alone couldn't be enough. Carter argues that the Commission reasonably determined that some non-retroactive legal changes, combined with other factors like serving at least 10 years of an unusually long sentence, can create truly extraordinary circumstances. He points out that a 70-year sentence would be drastically shorter if imposed today, likely around 21 years. He also emphasizes that the Commission's approach doesn't automatically make the First Step Act retroactive. It just allows courts to consider the resulting disparity as one factor in an individualized assessment. The government counters that the Sentencing Commission can't override Congress's deliberate choice to make the First Step Act's changes to Section 924C non-retroactive. They argue it would be illogical to call something extraordinary when it's the ordinary expected result of how Congress designed the law. They point out that when Congress wants to make sentencing changes retroactive, it knows how to do so explicitly, as it did with other parts of the First Step Act. The government argues that allowing courts to reduce sentences based on non-retroactive changes would effectively circumvent Congress's clear intent. The government also contends that adopting Carter's position would create arbitrary disparities, with sentence reductions depending solely on which circuit a defendant was convicted in. This case matters for hundreds of federal prisoners serving decades-long stacked sentences under the old version of Section 924C. It also raises fundamental questions about the separation of powers between Congress, the Sentencing Commission, and federal courts. The Supreme Court's decision will determine whether these prisoners have any chance at sentence reductions or whether they must serve their full terms despite the law now recognizing such sentences as excessive. We'll be following this case closely as it heads to oral arguments and beyond. The third case that the case called Ham v. Smith, case number 24-872. This case centers on how courts determine whether someone has an intellectual disability that would exempt them from execution. This case involves Joseph Smith, who was convicted of capital murder and sentenced to death in Alabama for a 1997 killing. After the Supreme Court's landmark 2002 decision in Atkins v. Virginia, which prohibited executing people with intellectual disabilities, Smith sought to prove he qualified for this protection. The key facts focus on Smith's IQ scores. Throughout his life, Smith's undergone 5 valid IQ tests, scoring 75, 74, 72, 78, and 74. Under Alabama law, to qualify as intellectually disabled, a person must show, first, significantly sub-average intellectual functioning, typically an IQ of 70 or below. Second, significant deficits in adaptive behavior. And third, that these conditions manifested before age 18. Smith's case has pinballed through the courts for years. After the state courts rejected his intellectual disability claim, a federal district court held an evidentiary hearing and found Smith intellectually disabled, vacating his death sentence. The court recognized that Smith's IQ scores were all above 70, but it considered the standard error of measurement in IQ testing, which meant his lowest score of 72 could actually reflect an IQ as low as 69. The court then examined Smith's adaptive functioning deficits, finding significant impairments in areas like social skills, self-direction, and functional academics. The 11th Circuit affirmed this decision. After an initial appeal to the Supreme Court, which sent the case back for clarification, the 11th Circuit again upheld the district court's finding, explaining that it had taken a holistic approach to Smith's multiple IQ scores. Alabama, the petitioner, makes two main arguments. First, they contend that states should be allowed to require defendants to prove an IQ of 70 or below by a preponderance of the evidence. They argue the lower courts improperly shifted the burden to the state to rule out the possibility of intellectual disability. Second, Alabama argues that multiple IQ scores above 70 should count against an intellectual disability finding. They point out that all 5 of Smith's scores were above 70 and argue that multiple scores together provide a more accurate assessment with a smaller margin of error than any single score. The state essentially argues that the 11th Circuit's approach makes the IQ prong meaningless. If someone with 5 scores all above 70 qualifies, they ask, then who wouldn't? Smith's legal team counters that the district court did exactly what Supreme Court precedent requires. They emphasize that both Hall v. Florida and Moore v. Texas directed courts to consider the standard error of measurement in IQ tests and to look at adaptive functioning evidence when scores fall in the borderline range of 70 to 75. They point out that the district court didn't rely solely on one IQ score, but considered all of Smith's scores, along with extensive evidence of his significant adaptive deficits. They note that Smith was placed in educable, mentally retarded classes in school, read at a 4th grade level as an adult, performed math at a kindergarten level, and showed major deficits in social functioning. Smith's team also argues there's no circuit split on this issue, contrary to Alabama's claims. They maintain that all circuits are properly following the Supreme Court's guidance in Hall and Moore. This case could significantly impact how intellectual disability is assessed in death penalty cases nationwide. If Alabama prevails, states might be able to enforce stricter IQ cutoffs, potentially limiting who qualifies for protection under Atkins. The case also raises questions about the balance of power between states and federal courts in defining intellectual disability and about how courts should handle multiple IQ scores that fall in the borderline range. With the Supreme Court granting review, oral arguments will likely take place this fall, with a decision expected sometime in the first half of 2026. The outcome could affect numerous death row inmates with borderline intellectual functioning across the country. We'll keep you updated as this important case proceeds through the Supreme Court. Those are the 3 certiorari grants from June 6th. There were, of course, certiorari denials, however, no denials penned a dissent. Thanks for tuning in to another episode of Supreme Court Oral Arguments and Opinions. If you found this deep dive into the court's strategic decision-making helpful, please subscribe to the podcast and share it with others who appreciate detailed legal analysis. As we head deeper into the court's summer recess and look ahead to the next term, I'll continue tracking the justices' evolving approaches to both their traditional merits docket and the increasingly important emergency docket. I'll be back soon with more Supreme Court coverage.